Thank you, Stephen, and good afternoon, everybody. It's great to have you all with us again today. I would like to welcome everybody to this, the third and the final procurement law webinar of the week. We've already had 2 days of presentation and discussion on a range of topics, which I hope you find to be stimulating and of relevance to your practice and to your work. And we're going to conclude today with what may be a slightly shorter session. We'll probably aim to finish by around 2 o'clock, but it will be of no less interest to you, I'm sure, as we've 2 exceptional speakers with us. We are delighted and honoured to welcome Mr. Justice David Barneville, currently, of course, a judge in the Irish Court of Appeal, and Catherine Donnelly, Senior Counsel, who have both somehow managed to find time in their incredibly busy schedules to participate and to provide us with their own reflections this afternoon. We're going to begin with Judge Barneville, and then we will pass over to Catherine, who will deliver the keynote address, and we propose then to have Q&A at the end. Once again, the chat room is open for anyone to raise questions or issues for discussion, and I really do hope that you make the use of what is a great opportunity today to engage with our speakers. So I will begin by introducing Judge Barneville. He was appointed a judge of the High Court in 2017, where he served as head of the commercial division. He was also designated to hear all arbitration matters in the High Court, and in 2018 was appointed a member of Ireland's national group on the Permanent Court of Arbitration in The Hague. In 2021, he was appointed judge of the Court of Appeal, and I know he has a keen interest in public procurement law and has delivered a number of important judgments in recent times, some of which were discussed earlier in the week. As I'm sure you're all aware, the government has just announced his nomination to be the next president of the High Court, a position which I understand he will take up next month. So many congratulations, Judge, on your appointment, and we very much look forward to hearing from you this afternoon.
Thanks very much, Peter, and thanks to Stephen and the Irish Centre for European Law for inviting me to participate in the final session of this year's annual conference and to make these brief introductory remarks. Of course, the big ticket item for today's session is Professor Catherine Donnelly's keynote address on origins, trends, and future challenges in public procurement. And before we sit back and listen to Catherine's presentation, something I know we all wait with keen anticipation and bated breath, I've been asked to give some reflections on procurement law from the bench, a somewhat daunting prospect, I have to admit. And the invitation to give reflections from the bench reminds me of the time when, shortly after I was appointed as the arbitration judge in the High Court, I was asked to speak at an international arbitration conference and to give, again, my reflections from the bench on the work of the arbitration judge. I confess, however, to feeling something of a fraud, as by that stage I hadn't heard a single case as the arbitration judge. And that's a little bit like how I feel today, giving these few brief reflections. It's not quite true, I suppose, that I haven't dealt with public procurement cases in the High Court or during my short period on the Court of Appeal. As Peter mentioned, I have done some, but I don't think I could really say that I have done so to the extent that anyone, still less this distinguished audience, would be particularly interested in hearing my reflections on those cases or on public procurement law in general. In contrast, however, over the past few days of this conference, you have all been treated to a host of expert speakers from Ireland and from further afield who have covered a vast range of contemporary topics in the area. The conference, I know, kicked off with Lord Justice McCluskey's presentation on public procurement developments in Northern Ireland. And Lord Justice McCluskey is, of course, the master or guru of procurement law on the Northern Ireland bench, and his judgments are regularly and almost routinely cited with approval by judges here, including by myself. Indeed, in the case of Transcore and the National Roads Authority, a case I decided back in October 2018 involving a challenge to the tender process for the operation of tolling operations on the M50 and elsewhere, and I referred with approval to at least two of his judgments. The first being Resources NI and the Northern Ireland Courts and Tribunals Service, where he famously described meetings of contract procurement evaluation panels as solemn exercises of critical importance to economic operators and the public, a phrase that has been repeatedly approved by courts here and in England and Wales and elsewhere. And the second being Clinton and the Department of Employment and Learning, where Lord Justice McCluskey, then a High Court judge, considered and set out in some detail the principles applicable to the interpretation of tender documents. And this conference was indeed very fortunate to have a speaker of such high reputation as Lord Justice McCluskey to kick off this jamboree of conference sessions over the past 3 days. And following hot on the heels of Lord Justice McCluskey was, of course, Donna Hardiman, who gave a comprehensive update on recent EU case law developments. And then Stephen Britton here gave his presentation on recent developments in the area of automatic suspensions following the recent decision of the Court of Appeal in Word Perfect back in November 2021. You then had the pleasure of hearing from another leading light in this area, Jonathan Newman, Senior Counsel, who with Catherine Donnelly seems to me, in my experience at least, to be in most, if not all, of the public procurement cases coming before the Irish courts. And Jonathan gave what can only be described as a tour de force presentation on recent developments on eligibility and standing in procurement challenges, in the course of which he considered another very recent judgment of the Court of Appeal in the same Word Perfect case decided earlier this month concerning the eligibility and standing requirements in Regulation 4 of the Remedies Regulations and Article 1.3 of the Remedies Directive. These impressive presentations were supplemented by comprehensive papers from Chris Murray and Abby Semple on UK public procurement reforms and sustainable procurement in Ireland and the EU. And now we have something which will no doubt be an equally impressive presentation by Professor Donnelly in her keynote address. But before we hear that, I just want to make some brief further observations, if I may. It's been a relatively busy period in the Court of Appeal with public procurement cases over the past 6 months or so. I mentioned earlier the judgment of the court last November in Word Perfect, in which the court allowed an appeal from the decision of Mr. Justice MacDonald in the High Court, which had lifted the automatic suspension on the conclusion of framework contracts in a tender process for Irish language translation services, and kept the suspension in place until the trial, which was to take place a small number of months later. Ultimately, following that trial, Mr. Justice Toomey in the High Court decided the case against the applicant on the eligibility or standing point. That decision was appealed to the Court of Appeal, and in a judgment delivered a couple of weeks ago, the court dismissed the applicant's appeal and upheld the decision of the High Court, and Jonathan Newman spoke about that case yesterday. The Court of Appeal has also very recently heard another important procurement case earlier this month in another Word Perfect case, which also involved an appeal from another decision of Mr. Justice Toomey in the High Court. That appeal concerned the legality of certain aspects of the procurement process for interpretation services, excluding Irish language services, and in particular the decision to divide the procurement into lots and to stipulate that any one tenderer could win only one of those lots. The appeal raised a number of very interesting issues. Not surprisingly, therefore, the court reserved its judgment at the conclusion of the hearing, and Catherine, of course, appeared in that case as well. And you'll no doubt also have heard in the course of this conference reference to the pay zone case involving a challenge to the tender process for the operation of the LEAP card for public transport services. An eligibility issue also arose in that case, and Mr. Justice O'Moore in the High Court found that the applicant was not an eligible person and was therefore not entitled to bring the challenge. That decision, should I say, was appealed to the Court of Appeal, and the court was due to hear that appeal last December, but at the request of the parties, the appeal was taken out of the list as they were apparently in negotiations to settle the case. As far as I'm aware, the case hasn't yet been settled and may still require to be heard by the Court of Appeal in due course, or perhaps events have overtaken that view. And it can be seen, therefore, that the Court of Appeal has been rather busy in public procurement cases over the last few months. And before speaking today, I made inquiries of the judge in charge of the commercial list in the High Court, to see whether there were many public procurement cases making their way through that list. I understand from that conversation that a number of procurement cases in that list have recently settled, and there hasn't really been an avalanche of cases coming through the list. It may be, and perhaps it's the case, that it's a brief lull, or perhaps even the calm before the coming storm. To conclude, in my relatively short period on the High Court and Court of Appeal dealing with procurement cases, I can say the following, and I'll end on this. We're extremely fortunate in this jurisdiction to have a number of really excellent and expert practitioners, both solicitors and counsel, working in this area. In my experience, that the cases tend to be, and in my universal experience, they are extremely well put together, very well run, and very well argued on both sides. Procurement cases are, by definition, difficult and complex cases. And the fact that the practitioners in the field are so skilled in the area makes it a hell of a lot easier to decide these cases than might otherwise be the case. So with those perhaps positive comments, I'm going to pass back to Peter to introduce Professor Donnelly. Thanks very much.
Thank you, Judge, for that. Catherine Donnelly needs little introduction to those who work in the area of public procurement. Catherine is a senior counsel and a fellow and associate professor of Trinity College in Dublin. She also has degrees from Oxford and Harvard, no less, and is a member of Blackstone Chambers in London. She practices in the Irish courts, the English courts, Northern Ireland courts, and has also appeared before the Court of Justice and the European Court of Human Rights. As you know, she regularly advises on public procurement issues and has acted in many, if not most, of the leading cases in recent times. And Catherine is going to deliver our keynote address today on the subject of public procurement, origins, trends, and future challenges. So Catherine, over to you. Thank you.
Thank you very much, Peter, and many thanks to you and Stephen for the invitation to speak today. I'm going to share my screen now, and hopefully that will work. And I hope everyone can see it now. Is that okay? Thank you. Yes, Stephen has indicated it's fine. So obviously this is a very open-ended title, doesn't give much away in terms of what I'll be speaking about today. Essentially, I'll be drawing together a number of disparate themes. I think hopefully there's some linkage, I think, between the origins and future challenges part of the paper, but the trends part, I think, is perhaps could be easily titled just a random few things that were interesting to me and that I might mention. But turning first to the origins and starting with that, there's a wonderful lecture that I would recommend to anyone who's interested in public procurement by Michael Bauscher, QC, who many of you know, and I've given you the link there, and it's Procurement Law and the Common Law Thread from Brexit to COVID. And I think it's a wonderful lecture in terms of going back to the essential purpose of public procurement. And I'm going to try to paraphrase a little bit and summarize a little bit of that lecture for you to start out today. And Michael talks about, procurement is the myths about public procurement and how it's often regarded as being a sort of a narrow, complex, technical subject, not really maybe of much use. Public sector bodies and politicians complain that it maybe inhibits their ability to act. It's sometimes described as an EU law invention, that it's unnecessarily complicated, that it's unnecessary. In the UK, of course, it didn't feature hugely in the Brexit debate, but it was certainly there as part of it. And I think at one point, Dominic Cummings spoke about, he described it as public procurement, the horror, and the new world that might arise if we didn't all have to deal with public procurement. And then the lecture goes on to talk about the importance of the function of public procurement. And we can see immediately, if we think about how much of GDP is spent in public procurement, the value of public procurement in the EU, I've just noted there something around 2 trillion in estimates. Ireland, accounts for 16% of GDP. Obviously, public procurement in terms of its function at a very basic level, seeks to secure good value for money, getting rid of corruption, dealing with public need. And of course, public procurement maybe was under the spotlight somewhat as well during the COVID pandemic, because there was a tremendous need for public sector activity, for public sector purchasing, and for the public sector to step in. So we do have an area of law with of fundamental importance. And it's also an area of law that didn't just start with the European Union or accession to the EU. And Michael gives this very interesting historical overview of public procurement, and he goes back to 1789 when the Navy in the UK moved to Somerset House, and they began a major programme of public contracts. And a sort of law and principles started to develop around the regulation of that at that time. In terms of the Second World War, the HMSO official history actually has one whole volume on public contracts, because they were so essential to governmental strategy and so essential to the war effort. And traditionally, in the UK at least, and elsewhere no doubt, public procurement was regulated through criminal law primarily. So bribery, fraud, and so on, and the exercise of public procurement would be regulated in that way. In the UK, there were some civil sanctions that were emerging in the common law, and actually there was a book written in 1972 before the UK accession on public procurement as it was developing in the common law at that time, and really, I suppose, primarily by reference to use of criminal law to regulate public procurement. And we also, in a very different and more extreme context, we have the example of Judge Falcone in Italy, who spent his life, as it were, fighting the Sicilian mafia, and public contracts, awards of public contracts was an essential part of all of that. And I think perhaps when we think about the importance of public procurement, we see that from the Brexit debate, the reality is, and I know you've had a lecture on this earlier in the week, but the reality is that there still has to be quite significant regulation of public procurement. To complain, therefore, that it is simply something sort of invented by the EU, or to have that perception, I think is, and that was a big part of the debate in the UK, but ultimately they find themselves post-Brexit with a very extensive regulation of public procurement. And on the EU role, Michael notes in his lecture that the original sin of EU public procurement was not to explain the underpinning rationale of public procurement properly, and that was that it introduced these directives, which were very focused on the internal market rationale and on free movement between member states, but which did not perhaps explain the underlying important public purpose of public procurement as clearly as might have been done, and sort of left it then to the Court of Justice to explain to us why principles of transparency and so on are of such importance. So Michael finishes his lecture by suggesting that really public procurement is so important that we should all be studying it at university, and sort of complaining about there's a kind of a lack of recognition and acknowledgement of the importance of this subject, which is rarely studied in university. And perhaps just in terms of the origins, and I said I am going to come back to this somewhat at the end of my presentation when I look at future challenges, but I think sometimes when we find ourselves caught up in the complexities of the very elaborate scheme of the directive and some of the challenges of public procurement law, it's important to remember its underlying public interest function, and it's important that the underlying public interest function maybe is not obscured by our association of this area of law with extremely complex rules as they are set down in the directive. So moving on then to some trends that I've noticed, and as I've mentioned at the start, I think largely these are just, I think, disparate issues that I have noticed in litigation practice and that are perhaps just worth mentioning. Obviously, the rules on EU public procurement are enforced through the Remedies Directive, through the mechanism of private enforcement, There are other ways that public procurement could be enforced, and we have parliamentary oversight to a degree, kind of ombudsperson oversight. But in terms of the primary mechanism of enforcement, it is down to the disappointed tenderers who bring their challenges. And in litigation, I just want to note 4 points that have been of interest to me in some recent cases around discovery, expert evidence, automatic suspensions, and damages awards. Now, in terms of discovery, I think many of you will, of course, be familiar with the 2020 Supreme Court ruling in the WordPerfect Translation Services case, which suggested that the problem of confidentiality in public procurement could be addressed by use of iterative or iterated discovery. And that was a process whereby a contracting authority could hand over certain documents at the discovery stage, unredacted, and one would come back then at the substantive hearing, and the trial judge could then decide whether or not they wanted to have sight of the unredacted documents or additional documents that had to be prepared by the contracting authority. So if you like, the contracting authority had to prepare 2 tranches of documents, one to hand over at the discovery stage, and the second held back in reserve for the hearing, possibly to be introduced then at the hearing. And this was the proposal that the Supreme Court held was suitable to deal with confidential documents, which is always an issue in public procurement. The court also suggested that it wasn't entirely enthusiastic about the usual method that, in my experience at least, has been used in discovery cases and had been used up to that point, of confidentiality rings, whereby certain documents are released unredacted, and others are released with redactions, and then the lawyers or sometimes experts can go into a confidentiality ring, look at the unredacted materials, and give an undertaking that they won't share any information with their client until either they bring a court application or there's consent of the successful tenderer or the contracting authority, depending on the source of the documents. That WordPerfect case actually settled after the Supreme Court ruling. So this new practice wasn't tested in it. And I'd be interested to hear if anyone has experienced this in practice, but I would just note myself that there hasn't been much interest or uptake in this approach, I've noticed, in procurement cases. And in general, parties are still using the old style confidentiality rings. And I suspect the reason for that may be because this process, this iterative process, does not really suit contracting authorities or applicants particularly well. And it creates problems for contracting authorities insofar as they may find themselves with, at a hearing, producing documents for the first time. That will almost certainly cause disruption at the hearing stage. An applicant may learn new information for the first time, may want to amend, and so on. And so I suspect that the reason this hasn't really been used in practice so much is because contracting authorities actually maybe find the confidentiality ring preferable in terms of its efficiency, and applicants will also prefer the confidentiality ring because they'll see anything to which they're entitled at an earlier stage. So I'd be interested to hear, as I say, if anyone has had a different experience from that, but just in my experience, confidentiality rings still seem to be preferred by both parties. Something else which has come up recently in the UK has been around the use of expert evidence in procurement cases. Now, we haven't really had any fights, to my knowledge, at least in Ireland, about use of expert evidence in procurement cases. It is often used, but it does tend to be by agreement between the parties. So the applicant will put in an expert report, then the respondent will respond to that. And I haven't come across any situations where the respondent has complained or the contracting authority has made an issue out of the fact that expert evidence has been adduced. And this issue does seem to be disputed more in the UK. There seems to be more fights over whether or not it's appropriate to use expert evidence in a procurement case and what its role might be. And there's been some useful discussion of that in the UK case, first in the UK cases, first in a 2012 judgment of BY Development, and then a more comprehensive and more recent consideration in ATOS Services, a 2022 judgment. In terms of the background facts, the dispute was around the purchase of a new supercomputer for use of the Meteorological Office. It was worth around 154 million. It was obviously a highly technical contract in terms of the specifications for the computer. And one of the requirements was around the offering put forward by tenders having to be architecturally equivalent with the requirements of the current computer system or the system that was in place. And there was a complaint about the applicant in this case. Its tender was not in fact deemed to be architecturally equivalent. And there's just a very useful discussion, I think, worth thinking about for us in this jurisdiction as well, about what the appropriate role is for expert evidence. And Judge Eyre held that really expert evidence procurement ought to be fairly exceptional, and it should really be on the basis that the court might not be able to reach a conclusion in the absence of expert evidence, but yet not to overemphasize the exceptionality, because there may well be circumstances in which it is appropriate and important to have expert evidence and when this will be permissible. If the ground of complaint is manifest error, a court should lean against admissibility of expert evidence, and it's not deemed to be normally admissible unless it's necessary to explain the technical concepts. So one can use expert evidence, as it were, to try to demonstrate, as the court put it, it was to show the way in which an error which led, or the reasoning in, an error in the reasoning which led to the decision, to show the materiality of the error in that chain of reasoning, was the language that the court used, to understand why it is said that the decision is erroneous, to perhaps assist with the incontrovertibility of the error, to assist in demonstrating that. But no opinions are admissible from an expert to say, well, the expert thinks that this error is a manifest error. So it's really only to explain technical concepts. So one needs to be mindful of the proper role of the expert evidence in that context. In terms of a breach of general principles, again, quite similar. It could be used to explain technical terms, the context of the procurement, particular circumstances in the industry. But for the rewind tenderer test, which is on the interpretation of the tender documents and whether or not the interpretation would be evident to the reasonably well-informed and normally diligent tenderer, no expert evidence is admissible on that particular issue, because that is always a matter for the court. And I know Judge Parneville mentioned Justice McCluskey's judgments, and that's something Judge McCluskey has given rulings on in the past in terms of that question being ultimately for the courts. And similarly, that was an issue that arose in the Transcore case that Justice Barneville gave ruling on. So it's quite nuanced, really, in terms of the role of expert evidence as set out in this judgment. Nothing can be the subject of expert evidence if it's to be for the ultimate determination of the court, but technical concepts that are part of the reasoning may be explained by expert evidence. And just to note also, one argument which I thought was quite ingenious on the part of the applicant was that the applicant argued that, or the claimant argued that it ought to be entitled to introduce expert evidence because otherwise the contracting authority might call an evaluator who would have expertise, and there would be an inequality of arms as between the claimant and this quasi-expert or expert evaluator called on the part of the contracting authority, and introduced just a sort of an equality of arms convention, Article 6 convention point, and that was dismissed. It was held that, well, that's sort of natural in procurement cases. It is always the case that there may be an expert evaluator involved in the process, and that's just something that goes with the territory, and certainly not a reason for allowing the introduction of expert evidence. So, as I've said, I haven't really come across any disputes myself as to the use of expert evidence in this jurisdiction, although it has certainly been used in a number of cases in which I've been involved. But if anyone's thinking about when they might want to bring in an expert, I think there's some useful guidance in that judgment. In terms of automatic suspensions, I know that Stephen gave his lecture on this on Monday, and I absolutely agree with what he has said in terms of the sufficiently serious breach really being the concession or the undertaking as to the seriousness of the breach has been used and is generally used in these cases to overcome that hurdle, as it were, to the lifting of the automatic suspension. Just to note one issue that I've observed in a number of English cases. In general, I think in the English case law, there's been a trend in favor of lifting the automatic suspension, but in two cases where it has not been lifted and which have sort of been exceptions to that trend, did find it interesting that there was a real emphasis placed on the early trial date, whether or not there could be an early trial date. And in both these cases, because an early trial date could be facilitated, the court was less inclined to be open to lifting the automatic suspension. And there's been some discussion in the UK as well about dividing up the cases and using modular trials by claimants, or claimants trying to get maybe the strongest part of their case on first, or perhaps part of their case which does not need as much disclosure, getting that on first in order to try to hold on to the automatic suspension. And it did get me thinking about whether or not in this jurisdiction it would maybe overly complicate what is already a very complicated process, but it may be something for applicants to think about if they think they may not have a great case on defeating the lifting of the automatic suspension, to think about whether there are aspects of their case that do not require discovery, or that could be run discreetly or could be run as net points, and to think about trying to hold on to the suspension for as long as it might take to hear a modular trial. Now, obviously that uses up court resources, and it does add some complexity, but it's just something that I've noticed that's happening in the UK and might be worth for some applicants considering here. And I would just note the Gaswise case. It's not known about this because obviously we just have the judgment, but interestingly in Gaswise, the respondent, the counsel did go into the commercial court and seek to have directions for the bringing of an application to lift the automatic suspension. And this was before Ms. Justice Finlay-Gagan, who refused to allow the counsel to bring that application on the basis that it would be quicker to get, that there was a capacity to get the case to hearing quickly, and that it would be a better use of court resources just to move the case on, rather than even to allow for the application to lift the automatic suspension to be heard. Now that was, I haven't seen that repeated, but that also maybe demonstrates the importance of holding of the date and the speed of getting to an early trial in terms of automatic suspensions. And then perhaps just the final trend I would note or issue just recently, there has been another interesting case. We have very little case law actually on calculation of damages in procurement cases, because often when the automatic suspension is lifted, the case ends up settling. I mean, that usually ends up happening because for an applicant, they might often lose the interest in proceeding. And rarely do we actually get to the stage where we have a full and comprehensive calculation of damages. The UK Supreme Court gave a ruling on the and adopted the same approach to the word perfect case here in terms of sufficiently serious breach being the threshold. And then there's a relatively recent judgment in Northern Ireland on damages in the McCann case. And just linking it back with automatic suspension, I think the court clearly was of the view that maybe it would have been better to not to have lifted the automatic suspension, or not to have had the applicant end up having to seek a damages remedy, and notes that the court had great difficulty in coming to a determination on damages. And it's often said that a court should not intervene by way of injunctive relief in circumstances where an award of damages is an appropriate alternative remedy, and then notes that this case demonstrates potential difficulty with such an approach, and sort of bemoans the fact that the court was compelled to determine the issue of damages. Now, there's a very lengthy background in this case. There had been, this for design and construction of a road. There had been a breach found because there had been an exclusion on the basis of an abnormally low tender, without allowing the tenderer an opportunity to explain the tender. So there had been a judgment on that. There had been a judgment then on the impact of nuclear decommissioning on the case. There was a third judgment then because the contracting authority, there was then a finding that the applicant had been involved in a cartel. And then the contracting authority wanted to rely on that to sort of break the chain of causation with damages, but ultimately decided not to pursue that. And then there's a judgment, quite a lengthy and detailed judgment, which I think does demonstrate the difficulty of calculating damages in some of these cases, and maybe ties into that recent word perfect judgment of the Court of Appeal in November, where that difficulty of calculating damages was to the fore in terms of the decision and not to lift the automatic suspension. It was an important part of the reasoning. And if one reads this judgment, and I won't get into all of the details, one really can have some sympathy for the trial judge trying to work out the damages. There were all sorts of claims. There were disputes about what would the target cost be. Well, that would be maybe what the successful contractor had agreed. There were outrun costs. That was issues about compensation events and whether or not the tenderer would have had similar compensation events. There were issues around overspending. There was a claim about an inability to supply aggregates from the applicant's quarry, which was rejected on the basis that there had been limited evidence. There were complaints about loss of rent, and there would have been rental of offices during the period of the contract. Just interestingly, on a point of principle for tender costs, those were regarded as the costs of doing business and would only be considered if all other heads of damages had been unsuccessful. So that's just a point of principle to emerge. Another interesting point of principle maybe was that there was a real skepticism about loss of future contracts being a recognizable head of damages. And, I do think in general courts are quite skeptical when it's an argument that's often run in an attempt to resist the lifting of the automatic suspension. I don't think it's rarely ever given much weight that the loss of the contract will mean that some future contract might not be won, or that some future qualification requirement might not be met. That's not an argument that I think the courts generally put much weight on, and we see that here again in the calculation of the damages. And then in terms of the overall assessment, so there was a full assessment done of the damages, and then for the loss of chance calculation, the court decided 50%. That's what the court came to on the facts, and then applied that deduction. So that's just a useful example there of a damages assessment, and it does really highlight the complexities that can be involved in reaching that endpoint and having to sort out damages. Turning then to the future challenges, I'm just going to look at 3 issues that I think seem to be on the agenda and seem to be increasing in importance. And some of this winds me back a little bit to where I started in terms of the origins and the importance of the function of public procurement. I think emergency purchasing obviously became a very important issue during COVID-19. I think In the UK, for example, there was an estimate of, in July 2020, in the first number of months of the pandemic, only 1% of new contracts were actually competitively tendered. And sorry, that's for COVID-19, so healthcare related. Obviously, we know that we're facing a number of challenges, maybe ongoing challenges constantly with energy supplies. There'll be housing. It seems inevitable that emergency purchasing will only increase in importance. And emergency purchasing is something that, has been problematic. There was a lot of discussion during the pandemic in the UK about connections leading to the award of contracts. So there's a lot of immediate debate around that. In Australia, there were problems during everyone might remember the Black Summer bushfires in 2019 to 2020, and the Royal Commission of Inquiry found that, there had been problems there with the emergency contracting that took place. And in Ireland, we haven't seen a lot of case law on this, but there is one case worth noting, and I think this was a judgment of Mr. Justice Barneville in his role as arbitration judge, potentially, which was the Naruma case. Where there had been, so one can see it, the panic buying that was obviously taking place. It was a purchase or a contract entered into by the HSE on the 27th of March, 2020, which, the schools had closed 2 weeks previously, and on the 27th, I think that was the day the Taoiseach announced, and really more increased major restrictions and the first full lockdown. And the HSE in this scenario, or in this contract, agreed to purchase 350 ventilators at a cost of almost 7.5 million from Naruma. And there's an email chain that one can see in the judgment. So this was all done very urgently. But then over the weekend, and there was a promise, that the HSE would pay the amount on the 30th of March. But then over the weekend, the HSE became concerned about whether or not this was a legitimate company. And as the court put it, the circumstances were unusual, to say the least, into which the contract was entered. Now, the rest of the judgment is all about an arbitration clause. So the HSE, the Naruma then sued the HSE for failure to pay, and then the HSE said that this was governed by an arbitration clause, and refused to, and that was ultimately the determination. So it had to be resolved by way of arbitration. But it is an interesting example of the issues that can arise with emergency purchasing. Now, we know we have accelerated procedures that are available in the directive, but if those are not available, there can be negotiated procedure without any notice, where it's strictly necessary for reasons of extreme urgency brought about by unforeseeable events. And that means that the time limits for proper procurement, whether under the accelerated procedures normally, cannot be met. And the circumstances giving rise to the extreme urgency cannot be attributable to the contracting authority. Now, I think it's fair to say that the Court of Justice has interpreted this provision extremely narrowly. And it is very rigorous with public bodies. So if, for example, there's an approval process that might have to be undertaken, that will not, the time taken for the approval process, say for planning or something, so that will not give rise to a reason, because that is foreseeable. So I think this Commission in Germany case involved dredging of the River Ems. If there's anything within the control of the contracting authority, such as if it has the capacity to set a deadline, that will again not be an unforeseeable event. In Commission in Spain, this involved a university or research facility, but upward trends in student numbers were perfectly foreseeable, and there could be no reliance on the Article 32 provision. Even forest fires are not deemed to be unforeseeable, unless there's some scientific report that suggests that there's new evidence. And similarly, in any delay between the contracting authority finding out about its need and actually engaging in its direct award or its negotiated procedure without competition will not indicate urgency. So there has to be extreme urgency. And the Court of Justice is absolutely rigorous in terms of its application of these procedures. And it's very, very difficult for any contracting authority to be able to take advantage of this. A different approach has been taken in the Good Law Project case in the UK. There was a much more generous approach to the public body in terms of reliance on Article 32. And this was a contract for focus group and communication services just at the very start of the pandemic, where the government immediately wanted to start holding focus groups. It wanted to get immediate results because it wanted to have an important communications engagement with the public. And there were arguments made by Good Law Project that it had not been strictly necessary to enter into this contract without following the procedures. And I think there's a few interesting points to take from this. There was the High Court judgment. It was appealed but upheld on appeal. The fact that there were other contracts in place with other providers of these services, but the court held that that did not mean that it was not strictly necessary to enter into this new contract because the contracting authority was entitled to decide which supplier was the appropriate supplier if the services were urgently needed. So the fact that there were lawful contracts and frameworks in place already to draw down the services did not undermine the strict necessity. In terms of the duration of the contract, it was for 6 months, and it was argued that this was too long, but the court held that that was a reasonable estimate in the circumstances. And there were other, and I think this is important for contracting bodies if they're entering into an emergency contract, there were other mechanisms in place in the contract in terms of early termination, only paying for services on a case-by-case basis, pay-as-you-go mechanisms, and these all meant that the contract had been sort of carefully tailored and was necessary. And then in terms of work done under the contract, the scope of work had been widely defined, but the court held that that was acceptable because it gave rise to flexibility for the contracting authority. So there, I think, there was quite a generous latitude, I think, given to the contracting authority. I think the approach is quite different to that of the Court of Justice. The court also didn't like the fact that some of the arguments maybe had the benefit of hindsight and were not sufficiently reflective of the challenge facing the contracting authority in its immediate context. But I think this is a very useful judgment for contracting authorities. Whether it's completely in line with what the Court of Justice might decide might be debatable, but it's certainly, I think, a very useful judgment for contracting authorities who may be dealing with emergency purchasing. And as I said, we've all sorts of issues in this jurisdiction that we might have to deal with involving emergency purchasing, including housing and so on. Linked to COVID may not be openly linked. It may not be, the link may not be so obvious. I'm just going to, sorry, there's a new, I'm going to go to, I'll come back to that slide in a moment, but there's a new proposal from the Commission on a foreign subsidies regulation. And this emerged from COVID-19. There was a concern here that the EU is overly reliant on Chinese, in particular, overly reliant on non-EU supply chains, and in particular, perhaps on Chinese manufacturing and production. And there's a concern that there are operators who are supplying in the EU who are benefiting from subsidies in third countries, and then that's undermining and distorting the internal EU market. And so there's a new regime that is coming in or being proposed, and the proposal has been published around foreign subsidies, and it's a new, almost parallel process, similar to the state aid process, but not quite the same, but involving notification requirements, an ability for the EU Commission to engage in own initiative investigations and investigations upon notification. And there's a very broad definition of the types of subsidies that might require notification, and there are all sorts of financial contributions that third countries might make to undertakings. And that's coming in not as not a procurement solely regime, but as a general regime. And just to go back then to my previous slide, this is Article 85 of the Utilities Directive, which doesn't get a lot of attention, but which does allow in certain circumstances for disqualification of tenderers that where they are products produced in a third country and there's no market access agreement with the EU, and there's a mechanism for price differentials, and there can be a scrutiny of those tenders that involve that emerge from third countries, as I said, that don't have a market access agreement. So that's sort of a very specific example of this underlying concern that the EU Commission has about the impact of subsidies elsewhere on the EU internal market. And it's a specific provision in the procurement context. I think I was asked to advise on it once and I couldn't really find much case law on it. So it's not something that comes up very often, but it is there. And now we see a much more expansive approach to this policy in terms of this regulation. And this proposal for this new regulation has a specific chapter on public procurement. And it will affect public tenders, and there'll be new obligations on tenderers to notify any support that they have been receiving from from outside the jurisdiction. And there are notification thresholds. The Commission might have to have an investigation, and there are various provisions for suspension of the award of the contract pending the outcome of the Commission's investigation. So I think that's something that will be coming down the tracks, and that's going to create the new complexities. And that was, that concern has been there in a small way in Article 85 of the Utilities Directive, but is now going to be coming in a much more comprehensive way. And the Commission will have power to demand commitments from these tenderers, and where those are not satisfactory, it may even prohibit the award of the contract to these tenderers. So, and we'll see how that gets on through the legislative process. And the last just update I wanted just to mention, and I think hopefully brings me back to where my lecture started, was about the importance of public procurement, horizontal policies and use of public procurement for, or secondary policies as it's sometimes known, to achieve objectives and public goals other than purely value for money. Obviously, public procurement has been recognised as a very long time as a way of achieving value for money and achieving public objectives. We had the New Deal in the US. We had Northern Ireland, the very good example of fair employment and treatment, Northern Ireland Order. We have Section 217 of the South African Constitution, which is post-apartheid. There are examples in the US when Southern Republicans and Democrats were opposed to equal treatment, that the US federal government would then introduce restrictions, or federal contracts could only be awarded to companies that observed equal treatment requirements. I'm just going to go through quickly. Obviously, there are many mechanisms for incorporation of horizontal policies into the public procurement process. One can do it through specifications and I know that you heard from Abby earlier in the week on green procurement in particular and sustainability. It can be done through contractor qualification, contract award, contract performance, and so on. Traditionally, the EU Commission has always been very resistant to use of public procurement for horizontal policies, because it was worried about incorporation of national preferences. But I would just note, and you'll see that the way in which it's restrained in the directive is that everything has to be linked to the subject matter of the contract. So any attempt to introduce a second policy is constrained with that requirement, which one finds throughout the directive in all of the different provisions. But I would just note just the second edition of the Buying Social, the Commission guidance, almost read to me a bit like a plea from the EU Commission to encourage public contracting authorities to start thinking seriously about using procurement for secondary policies. And the rationale is described as COVID-19 having had a regressive impact on achievement of a wide range of social goals, affecting employment, increasing inequalities, worsening precariousness, and that it's needed to address societal challenges, and that public authorities, you see there, need to step up efforts to deliver on all aspects of sustainability, and really trying to encourage contracting authorities to use socially responsible purchasing. And just, I'll finish up now, just sets out a range of goals and a range of benefits, and then gives lots of practical examples of how contracting authorities can use public contracts to achieve these public objectives. And it just seems to me, again, a bit like the emergency purchasing, it seems to me that this is a very important document that has been issued by the EU Commission. And it's really important in terms of encouraging public bodies to engage in socially responsible purchasing and the mechanisms that are available to them to do that. And there are lots of really interesting examples of what can be done, including contract performance conditions that include monitoring, or even payment by results, so that contracting bodies could pay depending on the social impact, and also social impact bonds. I just wanted to mention there, which can be used where you have a public buyer, a service provider, and a private investor who can be the risk taker. And these can be used to assist in trying to move towards a more outcome-based, socially responsible purchasing. So I just would mention that Commission document because I just think it's hugely important. And it seems to me to be inevitable that we will be moving really towards use of secondary policies and horizontal policies much more. Again, just given that rationale identified by the Commission, given all of the challenges that society is facing at the moment. And it may be that in the next iteration of the procurement directives, whenever that might be, the Commission might really have to look again at its restraints, the restraints that it imposes. But it certainly seems to me that this will become a very important feature moving forward and with increased attention. So I'll stop there. Thank you very much.
Thank you, Catherine, for that. Really interesting me. You covered a wide range of issues there, and certainly some of the hotter topics that we're all dealing with on a day-to-day basis. I might perhaps just invite Judge Barneville to comment on anything that he's heard from you there. Judge, is there anything in particular you want to observe on?
No, just thanks very much, Peter. Just to congratulate Catherine for a fantastic presentation. I don't think I'd know where to start in asking a question. She's covered so much territory in a very comprehensive and comprehensible manner. So I think she certainly pinpointed some of the key areas where we're likely to see further litigation and further disputes here. And I think she's offered some interesting pointers to people who wish to litigate certain issues. I probably shouldn't say any more than that, but it's it was a very, very interesting and very, very impressive presentation from Catherine. Thanks, Catherine.
I mean, Judge, you noted at the outset that you've seen an avalanche of cases in Ireland, and we certainly have much fewer cases here than in the UK. We're not getting, the automatic suspension applications. We're not getting the public interest cases. We're not getting these emergency contract disputes. I wonder if either you or Catherine have anything to say about the relative lack of procurement disputes that are, ultimately being decided by the courts here. I mean, we all know there are lots of disputes, but very, very few of them ever result in a full hearing or decision.
Just briefly, maybe for Catherine, will know much more of what's happening on the ground than I will. But there was a time where we used to have a lot of the applications to lift automatic suspensions, and there were several of them. There are lots of extempore judgments dealing with those issues, and a number of kind of more detailed judgments. But they all appeared to die out really with the word perfect judgment in the Court of Appeal in 2018, Mr. Justice Hogan's judgment. And it's only much more recently that people have started to adopt, as Stephen explained in his paper, the concession that if their damages were payable, they would be sufficiently serious under EU law. It's only more recently that that's been actually, I think, tried and ultimately found to be an appropriate approach in this jurisdiction. And it may well have been post word perfect. There was a skepticism as to whether the applications would ever succeed anymore. But as the more recent word perfect, the November 2021 Court of Appeal judgment shows, it's that there are a whole load of complex inputs into the ultimate decision on such an application that perhaps I'd be surprised if there weren't more of those applications now. I don't think, and Catherine will know much more, as I say, than I will. I don't think there have been that many more. And there's certainly, and just backing up a little bit, we did see, I think, before COVID and in the earlier stages of COVID, quite a number of public procurement cases coming into the commercial list. A lot of those cases seem to settle or die away. So maybe they will, hopefully they will come back, and for everybody who's dependent for their living on public procurement cases and for their profession, that you'll see more of those cases again, perhaps not for contracting authorities, and I'm sure they won't agree with that. Catherine.
I'm afraid I don't really have any answer to why we have less procurement challenges here than in the UK and elsewhere. So I do agree with what Mr. Sparneville just said there about the applications of the automatic suspension dying off after word perfect, but coming back a little bit now with the concession being offered. But more generally, in terms of why we don't have the same degree of litigation, I don't know. This is absolute speculation. I don't know if it's it's a smaller market. Do tenderers value their relationships more with the public bodies? Are they are they tendering repeatedly to the same public bodies? Are they more concerned that litigation might have a negative impact on that? And is that a feature of a smaller jurisdiction? I don't know. That's just a possibility in terms of the general attitude to procurement litigation in this jurisdiction. So I'm afraid I don't have any explanation. It does seem, I think, to come in cycles. So sometimes there are very busy periods and then less busy. I think sometimes if the economic environment is more challenging, procurement challenges can increase because economic operators become more dependent on public contracts. There may be less, less happening economically. So I do think that can sometimes be a feature in the cycles. But beyond that, I'm afraid I don't have any particular insights into why there might be that difference.
Do you have any concerns that the remedies framework is not effective for tenderers, and that the complexity, the practicality of it, in terms of its complexity and its cost, deters tenderers from pursuing disputes and obtaining satisfactory outcomes in many cases?
Well, I think that I know the EU Commission has had concerns. It used to have concerns about the UK and Ireland actually not providing a sufficiently effective remedy in procurement because of the fact that it was necessary to go to the court, because of the cost rules. Across some other, I mean, I can't speak with great expertise on this, but I know in some EU member states, there are tribunals, they have faster, they're more reactive. They maybe have faster disclosure of documents, for example, that were underpinning the process, whereas we have to go through our discovery rules. I mean, that is one feature, you know, they have an Article 84 file, but I don't know whoever gets to see the file, because we always have to justify it by reference to our discovery rules, and arguments that the principle of transparency, I think there was the Samag case where the principle of transparency was held to have an impact on procedural rules, such as the need for cross-examination. And that argument has not been successful in the discovery context. And so I do think there are some aspects of the procedure that maybe do mean it's quite an undertaking to bring a challenge, maybe more of an undertaking than in some other EU member states, although that doesn't necessarily explain the difference between the UK and Ireland, because we have effectively the same systems between the two jurisdictions. But I don't know, the EU Commission seems to have lost interest in this as an issue, but I do know that some years ago there was a lot of talk about how the EU Commission had concerns about Ireland and the UK.
Yeah, I mean, it's probably worth noting that, as was discussed earlier in the week, I mean, in Northern Ireland, there's been a fall off in the number of cases, whereas before, you know, there used to be, you know, numerous cases every year up there, and it is very inexpensive to at least commence litigation up there, and yet it's still there are fewer cases coming before the courts. But I'd be interested to get just Judge Barnable's views on that, and whether he thinks possibly with his new hat on, there's anything that might be done or might need to be done to facilitate procurement disputes, or is there does he see any prospect for there to be, you know, the kind of administrative tribunals that exist in other countries for resolving and providing more effective remedies?
Well, first of all, dealing with administrative tribunals, I don't think that's likely to be a reality here with our constitutional structure. It's not something I thought through very carefully, but I do think there would be a difficulty. You also see numerous references from civil law jurisdictions on public procurement issues to the Court of Justice, and they themselves then lead to considerable delays. I mean, some of the procedural complexities that you see in some of the European cases coming through, say, the Italian courts and various other courts, really are quite mind-boggling when you see the kind of knots they get themselves tied up in. So actually, I think our procedure here is more simple and simplified than it is in many of the European jurisdictions, and that's in my very limited experience of reading some of the European judgments. I mean, everybody always has a complaint about the cost of litigation here, and it is undoubtedly expensive to have to bring proceedings in the High Court. You do, as the challenger, have the advantage that you've got the automatic suspension, and the contracting authority then is the body that has to apply. And it's obviously in its interest, the interest of the contracting authorities, to have those applications dealt with as rapidly as possible. And there's this constant demand on resources of the court to try and get those applications heard as quickly as they possibly can be. Most of the cases, I think, although I'm open to correction on this, are coming through in the High Court, are coming through the commercial list. And the commercial list, and the judge now in charge of that list, and when I did that job last year, up to last year, the judge in charge of the list is extremely conscious of the importance of trying to get those cases on quickly, and they tend to be, particularly if it's an application to lift a suspension, dealt with very quickly. I mean, looking at the word perfect case that Mr. Justice MacDonald decided last year, that led to the appeal decided by the Court of Appeal in November, he dealt with that application phenomenally quickly and gave an extempore judgment overnight. Well, I think an extempore judgment, I think he might have taken overnight to do it. You know, very, very detailed judgment, extremely quickly. And then the Court of Appeal dealt with the appeal extremely quickly as well. So it can be done quickly here. One of the questions that may be implied, and one of the issues that may be implied in your question, is whether or not there's a need for a separate list to deal with procurement cases, more or less as there is in the UK and in the TCC. I think probably in that case, I don't think has yet been made. I don't think there are enough cases to justify such a list, but I'm certainly, and when I do take over my new position shortly, I'd certainly be open to submissions on that and to see whether such is necessary. For the moment, I'm not sure a compelling case is made for it, Peter.
Okay, thank you. Again, the chat room is open, so please, in the last couple of minutes, if anybody has any questions or issues they want to raise, please do. Just a question there from Stephen Carson in relation to the modular trials that you mentioned, and whether you envisage any particular practical issues with procurement actions being dealt with in a more modular fashion. I think a suggestion is there, one module may need to be appealed, and that may hold up other aspects of the case.
Absolutely. I mean, and well, I suppose if a procurement case were modularized, it would be the same issues as might arise with modularization of any case, I think. And, the courts in general tend to take the view that modularization is often not time efficient or cost effective because of the possibility of appeals, and because you might not have true savings of time. And as has been noted, there are already enormous pressures on the courts. But I suppose one thing to note about procurement cases is that they are often usually modularized in the sense that mostly liability is dealt with first, and it's just usually agreed between the parties that the issue of damages or reliefs will only be faced once liability has been determined. So evidence isn't even usually put in by an applicant on damages or loss in its first round of affidavits and so on. So there is a built-in modularization that generally takes place, but beyond that, breaking it down into issues, I do, as I said earlier, I do think it may become overly complex. But just seeing what was happening in the UK, it just struck me as to whether or not people might want to do something like that to try to hold on to the automatic suspension. But I could see how that might just create further complexities.
Okay, and then just finally, perhaps a second question there about damages, and I presume you would agree with that yes, damages can be extremely difficult to calculate in certain cases, but there will be other cases where it is much more straightforward, and almost every case is different, and there's a vast kind of range of scenarios in which damages might need to be calculated.
Absolutely. Yeah, it absolutely depends on the breach and the calculation of the loss of chance and so on. Yeah. So, I mean, there can be some cases where it'd be very obvious what the outcome might have been had the breach not taken place.
Okay. Unless there are any final observations or comments or questions, I think we'll probably wrap it up there. It's 2:15, and we give everybody some time back in the day. I just like to, for my part, like to thank everybody who's contributed, our speakers today, Judge Barneville, Catherine Donnelly, and everyone who contributed during the week. And thank you, the attendees for coming along and participating. And hope you find it interesting and informative. And on that note, I'll hand back to Stephen.
Thanks very much, Peter. And I'd like to thank, on behalf of the attendees and the speakers, I'd like to thank you for chairing the proceedings so well, and for managing the questions. And on behalf of the ICL, I'd just like to say that we're finishing up for the summer now, but we'll be running a full program of events in the autumn, including a competition law conference in September, a financial services law event in October, and an environmental law event in November. So hopefully we'll see you again at one of those events. Thank you very much.